I just want to welcome everyone to our July seminar for the Maternal and Child Health Student Association at UAB. Today we have a wonderful speaker who's going to be discussing a really great topic for everyone. We're going to have everyone muted at the beginning, but during the presentation, feel free to interrupt and ask questions at any time. And now I'm going to pass it to Julia to introduce our speaker for today.
We want to welcome you to Abortion in Alabama after Dobbs v. Jackson Women's Health Organization. Supreme Court in Dobbs effectively overturned Roe v. Wade, meaning the right to abortion was no longer federally protected. Now states can set their own abortion, opening up a seat. Our speaker today is the reproductive rights staff attorney for the ACLU of Alabama. Please welcome Kaitlin Welborn.
Hi, everyone, and thank you for having me. Oh, wait, my computer is trying to reboot just at the exact wrong time. Of course it is. Okay. Thank you so much for having me. And thank you in particular to Julia for inviting me. And I had the pleasure of working with Julia on a project not that long ago. So I'm really excited to be able to talk to y'all. So my plan is to go over the Dobbs decision and just discuss a little bit about the law and the reasoning about why Justice Alito came to the opinion that he did, then talk about what that means for Alabama, and then open it up to questions. But please interrupt me if you do have questions or if you don't understand something. There are no stupid questions, certainly when it comes to the law, but also when it comes to the Supreme Court, because they do whatever they want to do. And sometimes, a question that seems patently obvious is actually a pretty good question. So, you can put something in the chat, or if you want to unmute yourself and ask a question, please feel free to do so. But I want to leave a lot of time for y'all to ask questions, because my guess is that you, like the rest of the country, have a bunch of questions, and we'll see whether or not I can answer them. So, Julia gave a broad overview of the decision in Dobbs v. Jackson Women's Health Organization. That case concerned Mississippi's 15-week abortion ban. And I think the first thing that I want to start with is that we didn't actually have to be in this situation in the first place. So there's a principle called judicial restraint, where judges are really supposed to decide the most narrow issue possible. So they don't really consider hypotheticals or really what could happen in future cases. Just look at the facts at hand. This case only decide a rule that most narrowly applies to this case, and really don't think about anything else. And that's originally what Mississippi asked the Supreme Court to do. They said, consider this 15-week ban and consider whether under Planned Parenthood versus Casey, a case from the early 90s, which I'll talk about, whether any pre-viability bans on abortion are constitutional. So that's saying, before 22, 24 weeks, can states ban abortion? Under the case Planned Parenthood versus Casey from the early 90s, that is per se unconstitutional. Doesn't matter what time before then, but if it is a wholesale ban on abortion before viability, unconstitutional. So Mississippi says, look at our 15-week ban and ask, under Casey, should we really just take another look at it? And should the Supreme Court decide, actually, there are some pre-viability bans that are unconstitutional? The Supreme Court then let Mississippi sort of switch things up a little bit. And they added another question, which was, essentially, is Roe v. Wade constitutional? Should we wholly overturn or abrogate Roe v. Wade? So that was not their initial question. The Supreme Court didn't have to make this broad of a decision. They could have limited it just to 15 weeks, just to Mississippi. That's what John Roberts would have done. But they really reached out on a limb and decided we want to go way further than we have to just to make this decision. So I think setting it out like that, makes you think about how radical of a decision this really is. So we're not just talking about, overruling a precedent that we've had for 50 years, that is a watershed decision that, is so integral to the rights of women and low-income people and LGBT people. But we're going to go out on a limb and do something that we don't even have to do just so we can overturn Roe v. Wade. So that's really the starting point, is like, we didn't even have to be here, but Justice Alito wanted us to be here. So that's where we are. And, a fundamental principle of the Supreme Court is 5 votes win. So although there are these principles and canons that say, we should have never been here in the first place, it doesn't really matter when it comes down to it, because Justice Alito had 5 votes. So let me just walk through the decision, pretty quickly. It's a lengthy decision, but it's actually not all that complicated once you break it down. So Justice Alito starts by saying, okay, the court held in Roe that there was a constitutional right to abortion. It located that right in a bunch of different places within the Constitution. Overall, it said, yeah, there's a constitutional right to abortion. Then in the early 90s, the Supreme Court came back with Planned Parenthood versus Casey and said, okay, but that right is not unconditional. There are some times and places in which a state may restrict abortion. They can't ban pre-viability, but they can make some kinds of abortion restrictions so long as it does not place an undue burden on the person seeking an abortion. So that's why you're able to have things like waiting periods, parental consent requirements. In Alabama, they passed requirements for having to have an ambulatory surgical center or having to have admitting privileges in order to provide an abortion. There are a whole bunch of different kinds of abortion restrictions, and all of that was analyzed under this undue burden test. But Justice Alito says, Casey just sort of took it for granted that Roe was constitutional, which, in general is what judges do. They follow precedent and just, you follow what the court has done before you. So what Casey, in my view, did was not wrong. But Justice Alito said Casey basically rubber stamped Roe. It should have reevaluated whether Roe was right to begin with. And because Casey didn't do that, we're going to do that now. So, as I said, Roe located the right to abortion in a bunch of different places in the Constitution. And Justice Alito hammers home on this, all the time. The word abortion is not in the Constitution. It's not what's called an enumerated right. So things like, the First Amendment, freedom to speech, equal protection, the right to vote, things like that are really literally spelled out in the Constitution. Those are enumerated rights. So deciding whether something is or is not an enumerated right is pretty easy. In this case, abortion would not be one of those enumerated rights. The court in Casey and in Roe located the right to abortion in the Liberty Clause of the Due Process Clause of the 14th Amendment. So essentially, they said, in order for a person to, really enjoy their liberty and live the lives the way that they want to be able to, they need to be able to have a right to abortion. This same clause protects a lot of other rights that are not enumerated in the Constitution. So think about the right to marriage or the right to contraception, or just in general, the right to privacy outside of the Fourth Amendment, searches and seizures aspect. So, this one word is doing a lot of work, but it basically is saying, there are all these things that we know that we have rights for, that we have had for a really long time. It wasn't necessary in the Constitution to literally spell them all out. We know that they're contained in that one word. So Justice Alito says, all right, fine. Roe says we have an unenumerated right to abortion under the Liberty Clause of the Due Process Clause. And the test to determine whether an unenumerated right is constitutionally required is to ask whether this right is, quote, deeply rooted in our history and tradition, and whether it is essential to our nation's scheme of ordered liberty. So that's the test. You might notice, from the get-go, what is our history and tradition? Whose history and tradition are we talking about? How far does that go back? We know that history is, won by the victors, right? Like history is written by the victors. So history has been written consistently by white men, by ruling classes, by oppressors in general. So, just from that, oh, hello, my cat Ginsburg says hello. So just from that starting point, this test is really flawed because so much of what we consider to be rights in modern day life were not present back in our nation's history and tradition. And that's it's a good thing that we've evolved since then. But Justice Alito says, nope, this is the test. We have to look back at history. So he does a lot. He plays amateur historian, and he, goes back and looks at laws that were in effect when the amendment in question was ratified. So here we're talking about the 14th Amendment that was ratified back in 1868. So let's look at whether abortion was considered a right back in 1868. In 1868, I couldn't vote. A majority of people on this call couldn't vote. We couldn't hold property. There wasn't a federal law protecting women from being able to have their own credit cards until 1973. So, that test, talking about history and tradition, especially when we're talking about something that is so fundamental to women, to people of color, to low-income people, it's starting out already so skewed towards one side. So, he spends a lot of time going through history, and he, in fact, goes back to the 13th century multiple times. It's just a little bit absurd how much time he spends quoting a whole bunch of dead white dudes. But he focuses on this time of 1868 and says a lot of states made it a crime to have an abortion at that period in time. Therefore, abortion was not rooted in our nation's history and tradition. Therefore, it cannot be considered a right that is required by the Constitution, since it is unenumerated. So essentially, this test boils down to, could you have done it back in 1868? And if you could, great. And if you couldn't, too bad, so sad. That's what you're stuck with. Now, students of medical history will know that it's no coincidence that around 1868 and, that period of time, there were all of these laws passed restricting bodily autonomy, restricting women's autonomy. There was a confluence of events that led to that, including, immigration from unsavory countries, where, politicians really wanted rich white women to have children and not immigrants to have children. The increasing professionalism of obstetrics and gynecology, moving away from midwives and traditional practice done by women, and professionalizing that medical practice, the creation of the AMA. The AMA is really one of the leading organizations that promoted abortion bans back at this time. So when you look at just that period, yeah, there was not a right to abortion. But if you look back a little bit further and a little bit later, you will find that actually abortion was extremely common and extremely legal, particularly up until the point of quickening, which is generally when the fetus starts kicking, when you feel movement. So, we're talking way later in the second trimester usually. Abortion was a pretty common practice. And in fact, Justice Alito can really only quote a few criminal cases to show that abortion, was really something that people cared about putting people in jail for. It's also a little bit difficult when we're talking about a historical record to prove a negative. So if abortion was common and, not illegal, you're not going to find a whole lot of cases saying that. You're only going to find cases to the contrary. So the fact that Justice Alito only found a few cases, in my mind, proves the opposite of what he's trying to say. He's saying that shows that abortion was criminalized, whereas I think it actually shows if abortion were a really big deal to people at that time that they really wanted it criminalized, you would have a lot more cases he was able to come up with. So he's really cherry picking throughout history. Now, once he, goes through that really boring history lesson, he says the inescapable conclusion is that a right to abortion is not deeply rooted in our nation's history and traditions. The 14th Amendment's due process clause, therefore, does not provide a right to abortion. He also talks about what's called stare decisis, which is a legal term essentially meaning that judges should respect precedent, that a decision has to be really, really super wrong in order to reevaluate it. So that's, we're talking things like Plessy versus Ferguson cases, about slavery, that sort of stuff, where we know like that was really super wrong. Yes, it was right for the court to, reevaluate those cases, but they are very, very special. Here, Justice Alito says, okay, well, stare decisis is not an inexorable command. We don't always have to decide it. And, in this case, we really should relook at things because this case involves life. And so this case is so different and so special. Abortion is special, which is really a theme in abortion litigation, altogether, that we should treat it differently, unlike any other case. And yeah, we should definitely look at it again. And then he tries to take a bite out of Justice Thomas's concurrence, which you might have heard about. And he says, yeah, there are other cases that have, would undergo a similar kind of test if we looked at them again. So we're looking at, the right to contraception, the right to same-sex marriage, et cetera. Those are all located in the Liberty Clause of the Due Process Clause of the 14th Amendment. But Justice Alito says, don't worry, we're not coming after those. Don't freak out. Abortion is special. Abortion, he says it destroys what Roe and Casey call a potential life and what the law at issue regards as the life of unborn human beings. So it's special. What we're saying here about Roe only affects abortion. It doesn't affect Griswold and Eisenstadt, the laws, the cases protecting rights to contraception. It doesn't affect Lawrence, the law protecting the right to consensual same-sex activity. It doesn't affect Obergefell, the right to same-sex marriage. Don't freak out. Of course, Justice Thomas then comes along and says the exact opposite, and really we all should be freaking out about that. But that was actually one big change from the decision that leaked back in May, and the decision that ultimately came out is that Justice Alito spent, he at least added a paragraph saying this case is very special. It doesn't apply to anything else. Don't worry about all of your other rights that are located in, in the same part of the Constitution. Then he says, all right, so if there is no constitutional right to abortion, at least in the liberty clause, then we look at it under what's called rational basis review, which essentially says, does the legislature have a good reason for passing this law, or have a rational reason? It doesn't even have to be a good reason. And in fact, it doesn't even have to be the reason why the legislature passed it. If a legislature could have had a rational reason, even if it's a different one than what they used, then a law will be considered constitutional. So looking at the 15-week ban, now that he's gone through all of this and determined that there is no right to an abortion under the Constitution, at least under substantive due process, then he says, looking at rational basis review, legislature has respect for fetal life, and so they can basically do whatever they want. And so he declares that the 15-week ban in Mississippi is constitutional. So that's, basically the way that he gets there. It really sums up with, could it have been done in 1868? And if so, could they have had these kinds of bans back in 1868? And if so, then it's constitutional. So, that really previews what Justice Thomas looks at in his concurrence, where he says, in the span of 4 sentences, he says, Roe is wrongly decided. I'm really glad that we're looking at this again, because these cases were demonstrably erroneous decisions. In fact, we should look at a whole bunch of other decisions just like this. We should take another look at them, including Obergefell, the right to same-sex marriage, including Eisenstadt and Griswold, the rights to contraception. Let's look at those again. Those were also wrong. Look at them again. We should overturn them. So Justice Thomas is saying, actually, abortion's not special. We should not only take up these cases again, but when we take them up, we should overturn them. And in a certain way, he's right. When you look at the test that Justice Alito was using, things that are deeply rooted in our nation's history and tradition, you are not going to find a right to same-sex marriage. There was no right to same-sex marriage back in 1868. There was no right to interracial marriage back in 1868, which notably Clarence Thomas, whose wife is white, he leaves Loving versus Virginia out of the cases that should be reconsidered. You will not find a right to contraception deeply rooted in our nation's history back in 1868. So if the court does decide to take up these decisions again, and if they apply the same test that you are supposed to apply for unenumerated rights in the Constitution to things like contraception and same-sex marriage, the inevitable conclusion is that there is no constitutional right to those things. So if you're being, ideologically consistent, which I think Justice Thomas, although wrong, is being here, then we will not have any of those rights whatsoever. So, Justice Alito does try to tell us not to freak out a little bit, but I think if you take Justice Thomas at his word, and if you believe that the Supreme Court, should follow their own rules, which query whether or not they do, then yeah, those rights are up for grabs sometime soon. There are a couple of other concurrences. Justice Kavanaugh says, the Constitution doesn't say abortion. We're just leaving it back to the states. This doesn't ban abortion, but it doesn't make abortion legal. The states basically get to decide. That's a little bit of a red herring, because as soon as you say something is not protected by the Constitution, then it means that it can be banned. So it's not really like a both sides thing. Either abortion is protected or it's not. And when you say it's not protected by the Constitution, then it can be banned. So his reasoning doesn't really make a whole lot of sense. And I think, the fact that the word abortion isn't in the Constitution also doesn't really hold a whole lot of weight. The word women is not in the Constitution, even to this day. And there are a whole lot of words in the Constitution that frankly should not be there. So I think just looking at a single word doesn't really do justice to the kind of analytical rigor that we should have when analyzing constitutional rights. But don't tell Justice Kavanaugh, because I don't think he cares. And then Justice Roberts also, he says, okay, I would agree with this judgment as far as the 15 weeks part goes. I would uphold a 15-week abortion ban. I would not reconsider Roe and Casey. So I'm not going to join in all that part of the opinion. I'm just going to concur in the judgment and uphold Mississippi's 15-week abortion ban. The dissent is really fascinating and definitely worth a read. One thing that is notable about the decision or about the dissent is that it's a joint dissent written by the 3 dissenting justices. Typically, you would have one justice write a dissent and others would join on. That's a lot more practical. If you guys, you've had plenty of group projects in grad school, you know how hard it is to write a paper with a bunch of other people. So this is really quite unique to have all 3 justices simultaneously writing one unified dissent. And that just shows exactly how angry they are that, the court took up this case, much less that they came down with the decision that they did. You'll know that they also don't say that they respectfully dissent. They just say that they dissent, which in lawyer speak is like really nasty. They're being, that's, like a really big deal to them to take out the word respectfully. But I would encourage you to read it. It doesn't, mean anything because unfortunately it's not the law, but it might make you feel a little bit better if you are sad about the state of the world. So there's your legal lesson for the day. In terms of what this means for Alabama, abortion is illegal in Alabama, pretty much full stop. In 2019, they passed the, Fetal Life Protection Act, or the Human Life Protection Act, which bans abortion entirely, with one small exception for life or health of the pregnant person. It has to be a serious medical emergency, which is not particularly well defined. And that's going to be one of the big areas of litigation, not necessarily in Alabama, but I think definitely in the future. What does it mean to have a serious medical emergency? How serious does it have to be? Do you have to wait until someone is dying? What about if they are, they have a condition that they know will be life-threatening if the pregnancy continues, but right now it's not life-threatening? How close to death's doorstop do you have to be before an abortion will be legal? And I think reasonably so, doctors are going to be really afraid to make those decisions. In Alabama, abortion, performing an abortion is now punishable by up to 99 years in prison. It's the most severe penalty you can have in Alabama outside of the death penalty. So if you're trying to make a split-second decision about as a doctor, do I perform this abortion or not? And you're facing 99 years in prison, you're generally going to, lean on the side of not, just out of self-preservation. So, I would expect to see an increase in maternal mortality. And, I think the consequences that come along with that as a result of these kinds of laws where doctors are just not going to be sure about what the next step is going to be. And I can tell you that it's not like a rare occurrence. I was actually on a call recently with a bunch of providers who were asking questions about this exact issue. And they wanted to know about when you have a ruptured membrane. So essentially when your water breaks prematurely, is that considered a serious health risk? And if, the placenta and the uterine linings, if they all, stay inside of a uterus for a long period of time and they're not taken out, it can lead to sepsis and then to death. So, on the one hand, it's like, yeah, once you get sepsis, then you're going to die or you have a significant chance of dying. But if you just like let it wait, maybe it'll be okay. And doctors are confused about that. My cousin is actually pregnant, and at 22 weeks last week, her water broke and her membrane ruptured. So she is in this exact situation right now. Luckily, she's okay, and luckily right now the baby is okay. But when my cousin called and told me this, the very first question that came into my mind was, she lives in St. Louis. Is she in Illinois or is she in Missouri? Because it makes a huge difference. Right now, she's in Missouri. The only exception is that serious health risk. Those doctors are going to have to make those kinds of considerations. Whereas if she were just across the river, across the state line in Illinois, a doctor would feel free to actually make decisions based on, medical practice and not based on the threat of prison. I saw that someone in the chat mentioned that doctors can get 99 years for performing a life-saving procedure, but a rapist can be out in less than 10 years. That is true. There's also no exception in Alabama for rape or incest. There was talk of having a bill come back in this upcoming session next year to add rape or incest exceptions. Now the sponsor of the 2019 abortion ban has walked that back and said, actually, no, we're not going to have that. So the only exception in Alabama for now and for the likely future is just for serious health risk, not for rape or incest. And yes, a doctor will likely get more time in prison for performing an abortion than a rapist would for committing that rape. So that sucks. That's the technical legal term for this. Another thing to note, just sort of on the silver lining side of things, is that Alabama does not punish the person receiving the abortion. It is only the person who is performing the abortion. That said, Alabama has these really broad conceptions of conspiracy. And under Alabama's conspiracy statute, you can be liable for a crime for aiding and abetting that crime. You will receive the same punishment as if you committed that crime. So in this case, up to 99 years in prison. It's a minimum of 10, by the way. So, if you aid and abet an abortion, even if you didn't perform it, then you are liable as if you did perform the abortion. What does that mean if you aid and abet your own abortion is a really big question. And then another aspect that is really unique to Alabama is that if you aid and abet something that is legal in another state that would be illegal in Alabama, you can still be charged in Alabama. So let's say abortion is still legal in Florida right now. Let's say you drive someone across state lines to help them get an abortion, a legal abortion in Florida that would be illegal in Alabama. If that is considered aiding and abetting an abortion, you could still be charged for conspiracy to commit an abortion in Alabama, even though what you did was perfectly legal in Florida. That's true of all Alabama laws under conspiracy, but I think in this particular context where you have states that have wildly differing criminal laws on the subject now. That's something that is really quite scary and unique to Alabama. So I'm sure that y'all have lots of questions. Sorry for rambling on about the law for the past half an hour. I promise I won't take up any more of your time for that. But I would be happy to answer any questions that you have, or in general, just have a discussion about, the, Kat again, about the law and about, the future of what this means for people, people in Alabama, particularly pregnant people. And, I think also for, public health, what that is going to mean. Thank you. Thank you for loving my cat. Someone asked, in Alabama, were the fetal personhood laws used to punish pregnant people for using legal medications and cannabis, etc.? So it's actually not the fetal personhood laws that they're using, but they are using what's called a chemical endangerment law, which is meant to charge pregnant people who are using illegal drugs. So, question whether that is a good public health move to criminalize that activity, particularly if that means that would reduce people seeking out really important prenatal care or medical care in general. But those laws have also been applied to people using legal medications, so opioid prescriptions, for example. And in general, these laws are applied almost exclusively to Black women and to low-income women. And Alabama uses these laws way more than any other state in the country. I think that the National Advocates for Pregnant Women counted something like 1,200 cases in the past few years, and Alabama alone had over 300 of those. So Alabama is far and away the leader in using chemical endangerment laws to just further criminalize pregnancy. Someone asked, do these laws only apply to surgical abortions versus abortion medications? They apply to all abortions. And so that includes in-clinic abortions, so DNCs or other forms of abortions that you would have in a clinic, as well as medication abortion. It does not apply to emergency contraception, which is not an abortifacient. You wouldn't think that you would have to say that, but it is really important because there are some people out there who still think that emergency contraception, which is really just souped up birth control, causes abortions. It does not, but it does apply to medication abortion. One of the big questions now that you can have, you can order medication and have it sent to you in the mail, is the legality of that, right? So are you performing an abortion if you order that medication online, or if you receive it online? Does that count under the law? Is the person who is running that website, are they going to be liable for it? We just don't know. And so much is going to come down to individual prosecutors. A lot in criminal law comes down to individual prosecutors, but I think that you'll see it's less likely that someone will get charged for self-managing their abortion in bigger cities or in more progressive areas. But if you have a DA who's running for election somewhere, perhaps in a more rural area, perhaps not, they just want to show their bona fides, law and order bona fides, then I think that there is a significant chance that someone who is self-managing their abortion could be prosecuted for under the abortion laws. Then there are other laws that they could be prosecuted under. So perhaps that same chemical endangerment law. And then there are also laws about, controlled substances and using prescriptions for the right things. I think that we'll see a resurgence in using those those kinds of laws against people who are self-managing their own abortions, particularly because one of the medications, mifepristone, is really only used for abortions. And then misoprostol is used for a bunch of other things. So there are FDA regulations about mifepristone that it can only be dispensed in a it cannot be even dispensed in a pharmacy. It has to be in like a medical location. So I think that, we'll start seeing the weaponizing of the administrative state there to go after people who are, bending the regulations for self-managed abortion. Sorry, I'm going back through all of the questions. Would we need a more liberal Supreme Court? Yes, and file a lawsuit. So, if we want to change this law, there are two ways, really. Well, there are three ways to go about changing, let's just say, Alabama's law. One would be to go through the Alabama legislature. That ain't happening. Two would be to go through Congress. That's more likely to happen, but frankly, it's not going to happen under the filibuster. Just today, the House voted on a right to contraception and only 8 Republicans voted for it. So that's in the House. So they're not going to get 10 votes in the Senate to reach 60 votes to codify a right to abortion. And then the third would be to change the Supreme Court, either, adding seats or replacing people who are currently on them. But those are really the only ways. There are other causes of action that could lead to a right to abortion. So, when we were talking about Dobbs, that was all located in the Liberty Clause of the Due Process Clause of the 14th Amendment. A lot of people, including Ruth Bader Ginsburg, have said that that wasn't really the right place to locate the right to abortion, that really it should have been in the Equal Protection Clause, essentially the anti-discrimination clause of the 14th Amendment. And I think that's probably right. But would I bring a case right now, testing that theory? No, because I don't want this Supreme Court to rule on that. And that's going to create bad law for a really long time. So lawyers like me are really asking themselves, what cases can we bring that we think aren't going to create bad law? And sometimes the best answer is actually to not bring a case at all, which is really hard for me personally as a reproductive rights lawyer. That's why I went into this line of work. And I often now I'm feeling like there's very little that I can do because I don't want to. I could make things worse rather than just leaving things as they are. So frankly, our options are not great. I'm a joy at parties. Is it illegal to help others obtain medication abortion? We don't really know. This is another thing that I don't really enjoy is saying that we don't know a lot. It really just depends on how prosecutors are defining aiding and abetting. So when you say like help someone get a medication abortion, that could range from, making an appointment or buying the pills and putting them in someone's hand to, just putting information, linking to another website that talks about it. It's not really clear where prosecutors are going to draw that line. This has never been tested in a court before. So reasonably so, a lot of organizations have taken a very conservative with a small c view on the topic and have decided, we're not going to fund abortions anymore. We're not going to help, people travel out of state because a prosecutor could consider that aiding and abetting. And then under Alabama law, we would be, liable for the same 99 years in prison. Everyone is just going to have to make a risk calculation for themselves and the risk that they are comfortable with. I think for an individual person, and this is not legal advice, I think for any individual person, the risk is going to be low, right? Just as if it were for any other crime, the chances that one person gets caught for one crime, particularly one that's done, on the computer and in the mail and in your own home, is relatively low, although it's certainly higher for some populations than others. But when you start doing things on a larger scale and you start bringing attention to it, then you're much more likely to get caught. So I think that, everyone is just going to have to make a determination for themselves. Like, would I be okay, driving my sister across state lines versus, do I want to be the Yellowhammer Fund and, fund abortions, which they are no longer doing at this time. We're just not really sure. And we're not going to know, frankly, until people start getting charged. Let's say someone suspects you of helping a woman go out of state to have an abortion. What does the law say about Alabama prosecutors' ability to gather info from an out-of-state abortion provider? This is a good question. So they would have to subpoena that information, and it would have to be a HIPAA compliant subpoena, which is very difficult to get. So you have to go through a court to be able to get it. There are lots of procedures that you have to go through. Could it be done? Yes. Is it more difficult to do? Absolutely. And it will take a really long time. And I would imagine that in general, healthcare providers have an interest in fighting those subpoenas as much as possible. I think where you're more likely to wind up in, getting in trouble is apps and the internet. It's a lot easier to get, to subpoena your internet company and come up with your browser history or, where you went on Google Maps or whatever, than it is to get your records from an abortion clinic. And they would have a pretty good circumstantial case if, you went on Google Maps to, abortion clinic in that state and they have your credit card receipts that show that you stopped at the gas station along the way and, all this other stuff. So it is possible certainly to get those kinds of records, but I think they could probably make a case without it. And this is just my personal opinion, definitely not legal advice. Sorry that I have to keep saying that. It's, curse of a lawyer. Would medical records be used when someone crosses the border to Florida to get an abortion? Is it similar to Texas where you can turn people in for an abortion? So medical records could absolutely be used in a case, but like I just said, they're harder to get. And yeah, you can absolutely turn people in now because it's a crime. You could turn anybody in for any crime at any time. What is different about Alabama's abortion law compared to Texas's and now Oklahoma's is that they have the bounty hunter provision that makes it a civil enforcement, not just a crime. So, someone could sue the abortion provider in court for a minimum of $10,000. That you can't do at this point in Alabama. You can only do that in Texas and Oklahoma. But, could someone provide a tip to a police officer saying, I think so-and-so got an abortion? Yeah, they definitely could, because it's a crime just like any other. Does this apply to decisions making embryos created through artificial reproductive technology or IVF? So, in general, I would say no, because there's not cardiac activity at that point, which is generally how abortions are defined, at least at this time in the law. But I do think it is problematic that, in Georgia, they've now defined life beginning at conception. And once you do that, then yeah, I think like IVF and other, reproductive technologies can certainly come into question. Whether someone would be charged under, an abortion law is probably unlikely. But I do think it's possible to see an erosion of those kinds of rights and a chilling effect where people are going to want to be less likely to do it, less likely to pursue that kind of research or run that kind of business. Once you start defining, something as a person that begins at a time in which you don't know, that begins to become problematic really quickly. If people who seek abortion care and people who help are breaking the law, then what's the likelihood then of losing the right to vote? So fortunately, the right to vote is enumerated in the Constitution. That does not go through the same kind of test that Justice Alito went through. So we can be thankful for that. But we absolutely have reason to be concerned that we may not, quote unquote, lose our right to vote, but our right to vote could be diminished or quashed. In October, the ACLU and others are arguing a case in front of the Supreme Court about Alabama's congressional map, saying that it violates Section 2 of the Voting Rights Act because it has only one majority-minority district when it really should have two. A district court agreed with that, but the Supreme Court has put a stop to it and enjoined that decision, it prevented the injunction from going into effect. And that case has the potential to really get rid of the rest of the Voting Rights Act that the Supreme Court hasn't already gotten rid of. And then, I think we'll see even more erosion of the right to vote. So are we in danger of losing the right to vote? No, but should we be worried that our vote isn't going to count in the way that it should? I think a lot of people are worried about that, and with good reason. Do you know if physicians in Alabama are discussing how to navigate the laws in relationship to miscarriage management? There's been no public discussion at UAB, and this is worrisome for women's healthcare and maternal mortality. So there are a lot of questions about miscarriage management. And I think the easiest question is, is there cardiac activity? And if there's no cardiac activity, then it's not an abortion. And then you're just dealing, with miscarriage like normal. Where I think you're going to see a lot of problems is, when someone is miscarrying, but there is still cardiac activity, a very faint amount of cardiac activity, and where most physicians would say, okay, yeah, we're just going to go ahead and complete this as a miscarriage and not really think of it as an abortion. That is going to stop, basically. Because once there's cardiac activity, it is an abortion. And so, either you have to wait until the fetus fully dies, or you wait until someone goes into a serious health emergency. But again, what does that mean? So I think there are going to be lots of problems with that. And then the other area, sort of on the patient side of miscarriage management, is that there is no way to tell someone coming into a clinic, the difference between someone who has had a medication abortion and someone who has had a miscarriage. Like medically, there's no way to tell. So I think that there's going to be a lot of suspicion of people who are having miscarriages, who are having incomplete miscarriages, want to come in to, help complete that miscarriage, which is the same procedure as an abortion. And they're going to be questioned and, possibly turned over to the police as a result, because people will suspect that they had an abortion when really they're just having a miscarriage. We've already seen some of that in Texas. And, I think that that's something that we're going to see, all the time now. In Alabama, do we know if they would prosecute for spontaneous abortion? Yeah, I think that people are going to be accused of that for sure. We just don't know exactly how far things are going to go. And, honestly, like this is the answer to everything because we just don't know. None of this has happened before. There is no law on the issue. And like so much of criminal law, it's just going to come down to prosecutors, what they think the law can handle, what they think a jury will, whether a jury would convict, their caseloads, all that sort of stuff. Another thing to consider that I haven't mentioned, I don't think, is that if a prosecutor declines to bring a case in Alabama, the attorney general can step in and bring a case. So just because, you're safe because, you live in Birmingham, et cetera, it's unlikely that a prosecutor would bring that case, in Jefferson County or whatever. The attorney general can step in and bring that case instead. So, you're never really fully safe. Someone has asked, would it be considered aiding and abetting to help or offer to help a faculty member pay for travel out of state should they need life-saving treatment? Again, we don't really know for sure. But in Texas, the Freedom Caucus has sent a letter to a law firm, actually, a really big, fancy white shoe law firm, saying that they are in violation of the law in Texas by paying for their employees based in Texas to go out of state to have an abortion. That is not no one has prosecuted that yet. And we are talking about one small section of the Texas legislature, but they did say in that same letter that they are going to propose a bill to explicitly make that a crime. So I wouldn't be surprised if that's the same sort of stuff, laws that we'll see proposed in Alabama. So, we don't really know for sure right now. Again, it comes down to everybody's risk tolerance, but I think it's possible that those things could be enshrined into law in the future. So someone said, oh, hello again. So essentially, if you're an Alabama resident, you can't legally seek an abortion anywhere. Is that the case with all state by state laws? For instance, can an Alabama resident who goes on vacation in Colorado be prosecuted for smoking weed in a state where it is legal? So I don't want to definitively answer that question because I'm not a criminal lawyer, but my understanding of the conspiracy law is that aiding and abetting a crime that is legal somewhere else but illegal in Alabama can be charged in Alabama. I don't know that if committing the crime can be charged in the same way because it is a conspiracy statute, and so it requires two people. And it really is the aiding and abetting aspect. And I'm not a criminal lawyer, but I wouldn't put it past a prosecutor to bring those kinds of charges. And it's devastating to be charged with a crime, and have an investigation go on, even if you're not convicted, even if it never makes it to trial. So just because it's not illegal doesn't mean that a prosecutor won't bring charges, and it will still, harm someone's life. So we're not in a good place is really the summary of my presentation. And I really hope that a majority of your presentations are happier than mine are, because I really am a joy at parties as a result.
Thank you so much for sharing all of that wonderful information. It is a very tough topic, but important to talk about, especially now. So thank you so much for speaking with us and answering all of our questions. And thank you everyone for attending the seminar tonight. We will send out a survey evaluation later on to your email that you registered with. And I hope you guys enjoy the rest of your evening and weekend and stay safe.
Thank you all. Have a good weekend.
Do you mind if I ask one question before we go?
Oh yeah, go ahead.
What would your advice be to providers that are practicing and needing to make these decisions, like potentially life-saving decisions for their patients? What would your advice, your kind of legal advice, be to them right now?
Talk to your hospital's general counsel or your providers, your like practices lawyer ahead of time, so that you have sort of a set of guidelines before you have to make that split second decision. Because I was thinking about like my cousin's situation, and if like doctors are having to think about, well, what happens if her condition starts to severely deteriorate? And if I were those doctors, I would have been in the general counsel's office of the hospital as soon as she was admitted as a patient to try to figure that out now. Get it in writing, sort of like what was the process that you went through, and thinking about that, so that it's not just like a spur of the moment decision that you then have no like evidence to back up why you made the decision, the way that you did.
Thank you.
Yeah, absolutely. Okay, well, thank y'all so much and have a good night.